Hello viewers, in the last session we discussed about the securities, classification of securities, company and kinds of companies. In this lesson we are going to discuss about memorandum of association and alteration of association. The objectives of the lesson are A. To explain the fundamental documents of the company, B. To explain the procedure for alteration of fundamental documents of the company, C. To explain the powers of the company. Definition: Section 2, subsection 56 of the Act defines it as memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous company law or the present act. It is the fundamental document of the company on which the whole structure of the company stands. It is the charter or constitution of the company and defines its powers. It determines the relationship between the company and outsiders. Its purpose is to enable the shareholders and those who deal with the company to know what its permitted range of enterprise is. It is, as it were, the area beyond which the actions of the company cannot go. Purpose of memorandum. The purpose of memorandum is twofold. A. The prospective shareholders shall know the field in or the purpose for which their money is going to be used by the company and what risk they are undertaking in making investment. B. The outsiders dealing with the company shall know with certainty as to what the objects of the company are and as to whether the contractual relation into which they contemplate to enter with the company is within the objects of the company. Cotman versus Broham, 1918, AC 514. Form of memorandum. The Act prescribes 4 forms of memorandum and they are set out in tables A, B, C, D and E in Schedule 1 as follows. Table A is applicable to companies limited by shares. Table B is applicable to companies limited by guarantee and not having share capital. Table C is applicable to companies limited by guarantee and having share capital. Table D is applicable to unlimited companies and not having share capital. Table E is applicable to unlimited companies and having share capital. Contents of memorandum. Its importance lies in the fact that it contains the following fundamental clauses which have often been described as the conditions of the company's incorporation. 1. The name clause. 2. Registered office or situation clause. 3. Object clause. 4. Liability clause. 5. Capital clause. 1. Name clause. Section 4. The name of a company establishes its identity and is the symbol of its existence. According to Section 4, subsection 1, clause A, the memorandum of a company shall state the name of the company with the last word limited in the case of a public company, or the last words private limited in the case of a private limited company, provided that nothing in this clause shall apply to a company registered under section 8 of the Act. The name stated in the memorandum shall not A. be identical with or resemble too nearly to the name of an existing company registered under this Act or any previous company law, or B. be such that its use by the company 1. will constitute an offence under any law for the time being in force, or 2. is undesirable in the opinion of the central government. The name should not indicate connection with or patronage of government. According to section 12 of the Act, the name of the company must be painted on the outside of every place where the company carries on business and printed on every business document and official letter. Misdescription of name entails personal liability. Advance reservation of name. According to section 4, subsection 4 of the Act, a person may make an application in a prescribed form and manner and on payment of prescribed fee for reserving name for the proposed company or for changing the name of an existing company. Such name may be reserved for 60 days from the date of application. If no such company is formed, the reservation is to be cancelled and the applicant is to be punished with fine extending up to 1 lakh rupees. It should not contravene the provisions of the Emblems and Names Prevention of Improper Use Act 1950. Explaining the reasons for not allowing an identical name to a new company, Lord Lawrence, Justice in Society of Motor Manufacturers and Traders Limited versus Motor Manufacturers and Traders Mutual Insurance Company Limited, 1925, 1 Chancery 675, observed, no other company can be registered under a name identical with it or so nearly resembling it as to be calculated to deceive. Since the name of a company is a part of its business reputation and that it would definitely be injured if a new company could adopt an allied name. In the instant case, the plaintiff company was incorporated under the name the Society of Motor Manufacturers and Traders Limited in 1902. Later, in 1924, the defendant company was incorporated under the name Motor Manufacturers and Traders Mutual Insurance Company Limited. The plaintiff company sued the defendant company for adopting an identical name on the ground that it was deceptive and prayed that the defendant be restrained from using this name. The court ruled that the defendant company's name could not be regarded as one calculated to deceive in as much as it was an insurance company, whereas the plaintiff company was a motor manufacturer and trading company. Thus, a person with ordinary prudence would see that the business of these two companies is distinctly different from one another, and therefore, there was no reason for any confusion because of similarity in the names of the two. Where the company is with meager sources, but the name suggests that it has a large scale business or its trading extends over a wide field, it shall be treated as a misleading and deceptive. Explaining this aspect further, the government has issued clarifications and the words suggesting scale of business are described in keywords as follows. 1. The word corporation should be used by companies with authorized capital of 5 crore rupees and above. 2. The word international, universal, continental, intercontinental, Asiatic, etc. as the first word of the name can be used by companies having capital of rupees 1 crore, and if any of these words are used in the name with or without brackets, but not as the first word of the name, the company should have a capital of minimum 50 lakh rupees. 3. For using the word industries, Udyog, rupees 10 lakhs. Deliberate omission to mention the word limited as the last word in company's name may lead to serious consequences, and the directors may be held personally liable for this default. Venture capital companies. According to the government's direction, venture capital companies' names must be ended with venture capital fund or venture capital finance companies to seek tax exemption. 1-person company. In case of 1-person company, the words 1-person company shall be mentioned in brackets below the name of such company wherever its name is printed, affixed or engraved. 2. Registered office class. According to section 12 of the Act, the memorandum must specify the state in which the registered office of the company is situated. However, the company is not required to mention the exact address of the registered office. Within 30 days of incorporation or commencement of business, whichever is earlier, the exact place where the registered office is to be located must be decided, and notice of the location must be given to the registrar, who has to record the same. All official communications to the company must be addressed to its registered office only. It should also obtain its corporate identity number. The company shall get its name, address of its registered office, telephone number, email and website address printed on its official documents. 3. Object class. According to section 4 subsection 1 class C of the Act, the company should mention in the third class the object for which the company is proposed to be incorporated and any matter considered necessary in furtherance thereof. 4. Liability class. According to section 4 subsection 1 class D of the Act, the fourth clause has to state the nature of liability that the member incurs. 5. Capital clause. According to section 4 subsection 1 clause E of the Act, the fifth clause has to state the amount of nominal capital of the company and the number and the value of the shares into which it is divided. Subscription. The memorandum concludes with the subscriber's declaration. The subscribers declare, we, the several persons whose names and addresses are subscribed, are desirous of being formed into a company in pursuance of this memorandum of association, and we respectively agree to take the number of shares in the capital of the company set opposite our respective names. According to section 3 of the Act, the memorandum and articles have to be subscribed by at least 7 persons in the case of a public company and by at least 2 persons in the case of a private company. Each subscriber must sign the document and must write opposite his name the number of shares he takes, but no subscriber shall take less than 1 share. Alteration of Memorandum of Association. 1. Alteration of name class. According to section 16 subsection 1 of the Act, if it is subsequently found that through inadvertence or otherwise a company is registered with a name which appears to be undesirable or is identical with or too nearly resembles the name of a company which is already in existence, the central government has power to direct the company to change or rectify its name by passing an ordinary resolution within 6 months from the date of receiving the direction from the central government. Where a company changes its name within a period of 15 days from the date of such change, give notice of the change to the registrar along with the order of the central government, who shall carry out the necessary changes in the certificate of incorporation and the memorandum. If a company makes default in complying with any direction given by the central government, the company shall be punishable with fine of 1000 rupees for every day during which the default continues, and every officer who is in default shall be punishable with fine which shall not be less than 5000 rupees, which may extend to 1 lakh rupees. A change of name does not affect any rights or obligations of the company or any legal proceedings by or against it. According to section 13, subsection 2 of the Act, a company may change its name voluntarily by passing special resolution and with the written approval of the central government. The powers of the central government to accord approval to the change of the name have been delegated to the registrar of companies. However, if the change pertains to only the addition or deletion of the word private to the name, the approval of the central government shall not be necessary. Alteration of registered office class. A company can shift its registered office from one place to another place within the same village, town or city by passing a resolution at the board of directors meeting. According to section 12 of the Act, a company proposes to change its registered office from one city to another city within the same state. It can do so only after passing a special resolution at the general body meeting. A notice of any such change has also to be given to the ROC within 30 days of the change. In case of default, the company and every officer who is responsible for this default is liable to punishment with fine extending up to 1000 rupees for every day during which default continues, but not exceeding 1 lakh rupees. Where the company wants to shift its registered office from one place to another within the same state, from the jurisdiction of one registrar of companies to the jurisdiction of another registrar of companies, confirmation by the regional director shall be mandatory for such a change. For this purpose, the company shall make an application to the regional director in the prescribed form, and the confirmation shall be communicated within 4 weeks from the date of receipt of the application. According to section 13 of the Act, a company can shift its registered office from one state to another state only by passing a special resolution and prior approval of the central government. Before granting permission to change the registered office, the central government must be satisfied that sufficient notice has been given to every debenture holder, creditor, and to every other person or class of persons whose interest will, in the opinion of the central government, be affected by such alteration, and the permission should be given only after the company taking their consent for alteration, otherwise their claims should be discharged. 3. Alteration of object class. According to section 13, subsection 8 of the Act, a company can change its object class simply by passing special resolution. The prescribed details of the resolution should be published in the newspaper, and the same has to be placed in the website of the company. The dissenting shareholders have to be given an opportunity to leave the company if they so desire. 4. Alteration of liability class. A company cannot alter its liability class so as to enhance the liability of its members or compelling them to take further shares. Such an alteration would be void in law. 5. Alteration of capital class. This topic we will discuss in detail in share and share capital chapter. Object clause and doctrine of ultra vires. Ultra means beyond and vires means powers, and ultra vires means beyond the powers of the company or objects of the company. In Foster versus London Gotham and Dover Company 1895 1 QB 711, it was observed that a company has the power to do all such things as are A. authorized to be done by the Act, B. essential to the attainment of its objects specified in the memorandum, C. reasonable and fairly incidental to its objects. The purpose of this doctrine is to protect the investors in the company so that they may know the objects in which their money is to be employed, and creditors by ensuring that the company's funds are not wasted in unauthorized activities. If an act is ultra vires the objects of the company, such an act is absolutely void, and even the whole body of shareholders cannot ratify it and make it binding on the company. The leading case on this aspect is Ashbury Railway Carriage and Iron Company Limited versus Ritchie 1875 LR 7 HL 653. The facts of the case are: the company was incorporated with the following objects: A. to make and sell or lend on hire railway carriages and wagons, B. to carry on the business of mechanical engineers and general contractors, C. to purchase, lease, work and sell mines, minerals, land and buildings. The company entered into a contract with Ritchie for the financing of the construction of a railway line in Belgium. The question raised was whether that contract was covered within the meaning of the general contractors. The House of Lords held that the contract was ultra vires the company and void, so that not even the subsequent assent of the whole body of shareholders could ratify it. Ultra vires the directors but intra vires the articles. If an act of the company is ultra vires the directors but intra vires the articles, the shareholders can ratify it by passing an ordinary resolution at the general body meeting. Ultra vires the articles but intra vires the memorandum. If an act of the company is ultra vires the articles of the company but intra vires the memorandum of the company, the shareholders can ratify it by passing a special resolution in the general body meeting. In Attorney General versus Great Eastern Railway Company 1880 LR 5 AC 473, the House of Lords observed that the doctrine of ultra vires, as it was explained in the Ashbury case, should be maintained, but it ought to be reasonable and not unreasonably understood and applied, and that whatever may be fairly regarded as incidental to the objects authorized ought not to be held as ultra vires unless it is expressly prohibited. Thus, a company may do an act which is A. necessary for, or B. incidental to the attainment of its objects, or C. which is otherwise authorized by the act. Thus, in Forest versus Manchester Railway Company 54 ER 803 1861, a railway company having authority to keep steam vessels for the purpose of a ferry may use them for excursion trips to the sea when they are otherwise unemployed. In Forest versus London, Gotham and Dovery Railway Company, 1895, 1 QB 711, a railway company whose railroad is carried over arches may convert the arches into shops. Similarly, in Evans versus Brunner, Mond and Company, 1921, 1 CH 359, a chemical manufacturer was allowed to distribute 1 lakh pounds to scientific institutions for the furtherance of scientific education and research, as it was conducive to the continued progress of the company as chemical manufacturers. Consequences of an ultra vires transaction. A. Injunction. Whenever an ultra vires act has been undertaken by the company, any member of the company can get an injunction to restrain it from proceeding with it. B. Personal liability of directors. In case of ultra vires transaction of the company is not liable, but the directors are personally liable. C. Ultra vires contracts. Ultra vires contracts are void ab initio and not binding on the company. D. Ultra vires lending of money. In case company gives loan to the outsider, which is ultra vires, the outsiders cannot set up ultra vires as a defense. E. Ultra vires acquisition of property. Subrogation. In case the company has paid off lawful debts with an ultra vires loan, in such a case the lender would stand subrogated to the position of the debtor and shall have right to recover from the company to that extent. This was held in Neath Building Society versus Lewis, 1889, 43, CH 158. Restitution or tracing order. In Sinclair versus Broham, 1914, AC 398, it was held that if the company has purchased any property or goods out of the ultra vires loan and the creditor can trace and identify the money lent or any property or goods which the company has purchased with it, he can obtain a tracing order and claim for restitution of that money. G. Ultra vires torts. To make the company vicariously liable for the tortious acts of the employees of the company, the tort must be committed by the employee in the course of employment and out of employment, otherwise the company is not liable. So, in this lesson, we discussed about the fundamental documents of the company, that is Memorandum of Association, and in case the company violates the object clause of the company, it amounts to doctrine of ultra vires, and what are the consequences of ultra vires we discussed. I hope you enjoyed the lesson and we will meet in the next session. Thank you.